My name's Brian Goldberg. I'm from EKM Patent and Trademark in Australia. I'll read my slides just because I know then that definitely sticks into the time limit, and Kimberly will invite me back next time. I thought I'd start with something that might be slightly different and then go through the other scope of the patent aspects that we're looking at, and that's an innovation patent. In Australia we have something that's known as an innovation patent, and it's intended to provide IP rights for those incremental and lower level inventions that would not sufficiently be inventive to qualify for a standard patent. So it's got a lower threshold than a normal inventive, so it's called, all you need is an innovative step. Some benefits are that from an enforcement perspective, once you have it certified, it's a process as well, it automatically gets granted, and then you need an examination for certification. Once it's certified, it's legally enforceable, and that's probably its strongest benefit. You can still convert it back to a standard patent, but there's a quick time limit of a month before this one would be granted. It's fast because you instantly get a granted innovation patent, and because of the lower threshold, it's actually harder to invalidate, so you can be in a strong position to enforce it. Some further benefits are that if examined and certified, the innovation patent offers the same level of protection, and in Australia there's not that many infringement matters in the patent area due to the costs in other areas and the time taken, but this is certainly an avenue that the patent holders are looking at to enforce their rights. It's cost effective both from a filing point of view as well as knowing that you're going to get it certified and granted means you can put the budget in place, or your clients can put the budget in place to do the enforcement quite confidently. However, there are limits. The limits is it's Australia only. It's 8 years. You only get the rights for 8 years, not 20. And there's actually only, I didn't put it in there, only 5 claims allowable in an innovation patent, so you'd have to think through the 5 most relevant claims. And as I said, initially it was probably taken not so quickly, but now it's certainly being used in the IP portfolio management of companies in Australia. So moving to the normal line, the deadline in Australia is 31 months from the earliest priority claim, and just to make a note that there's no power of attorney or authorisation agent required for national phase or convention applications. Extensions, so as long as you don't unintentionally miss doing something or paying the fee, you can apply for an extension under Section 223 of the Patents Act. So probably the only thing you could do to muck this up is send us an email saying our client does not intend to proceed, and then a month later get an email, oh, by the way, he's changed his mind, he wants to proceed. So if you don't do that, it's usually okay. The 2 main reasons are an error or omission by your self-employee, agent or attorney, or circumstances beyond your control. Delays in post-courier, sickness, accident, and that's not a definitive list, so we could add into there. However, it doesn't cover for lack of funds to pay excessive fees. So if the client didn't continue because of fees at the time, that's not a strong enough reason. And the applications for an extension of more than 3 months are advertised by the Patent Office. In terms of patent fee increases, on the 29th of June, the government approved increases in patent fees, which came into effect on the 1st of August. The total patent revenue for the financial year had increased by 6.8%, so that's a small indication for us. But probably what's important from a day-to-day basis, if you are dealing with Australia, is that our dollar has actually increased. Now it's for the first time in my life, so for about closer to 40 years, it's above parity with the US dollar. And I haven't checked today, but it was $1.07 when we left, which is very unusual. 10 years ago it was 50 cents to the dollar to the US, then it lingered about the 60, 70, and now to be above parity. So the firms, including us, we all haven't worked out where we're going to hedge our bets, but that has increased the costs, and something to note from a more daily basis. Acceleration, presently it's taking about 3 years to get an examination report. In fact, what IP Australia, the governing body in Australia, have done, probably quite at the forefront of patent examination, is they've set up a patent factory outside the patent office in a capital city, just across the road from us actually, in Melbourne. And they've just got patent examiners sitting there in a factory environment churning out patent examinations. So they're very well set up for patent examinations, and to attract those people, they needed to relocate to the main cities. And the main reason that you'd want to accelerate, or that's accepted, are either possible infringement reasons that you'd like to enforce your rights, as well as commercial reasons such as entering into license agreements, because in Australia we understand the bigger markets internationally, so that's a good reason to have your patent accelerated. And then it takes about 10 to 15 weeks, which is quite reasonable, and as I said, they're set up well to do that. We also have green technology, so if your patent application, if you want it to be examined more quickly and it falls into a green technology, there is an avenue. I don't think any email is required. I think you just write green technology and you get that opportunity. And as well, we've entered with the US into the patent prosecution highway program, and some of, I'll just read out the main aspects that need to confide to go along that path. The Australian claims must be sufficiently correspond with one or more of the claims of the allowable claims in the US application, and it must be linked to a common US priority claim or have a common initial filing date. The Australian application must not already have been examined by the Australian Patent Office, so nothing too different there, and we're part of that. I'll say very quickly, in terms of software and business methods, the answer is yes. Yes to software, a mode or manner of achieving an end result that is, we term, artificially created. A lot of flowcharts in the patent applications, and very popular at the moment in Australia. I've got to admit, being a smaller market, it's popular in the sense that they would like a big US firm to say, we need that exact application, rather than do it themselves in Australia. So they do look to protect the patent as their only form of asset in Australia, and then seek a license deal. So it is very popular to see a lot of drafted IT or software patent applications, as well as business methods. The answer is yes. And with the slight differentiation with the business method, with like a technical solution or technical advantage. But once again, artificially created gets you in the scope of justification. Disclosure requirements, well, there's been a removal of the obligation to lodge search results, so it's now relatively straightforward and the onus has been taken away. And my final slide, what's the Australian, or the relevance of the Australian market? Well, we are diverse, and we do have various aspects. Certainly medical devices rate high. We have a high level of medical expertise. Hardware, electricals, software and business methods, but for that reason more than being an end market. Mining is certainly a boom at the moment that's running our whole economy, but is dominated by some larger players and quite controlled in Australia. Household goods, sports, definitely in the sports area, transport, chemical, biotechnology and pharmaceutical. So we do cover a wide range, and in fact our clients also cover that aspect, so it is a broad area. So thank you very much.